Well, I have 6 o'clock on my clock here. I know that there are people who have not joined us and are continuing to join us as we get started, but I did not want to take up a lot of your time waiting because we do have a lot of information to go to today. If you saw through our agenda, we have a presentation on our Child Support Enforcement Agency. But first, we're going to start with one of our supervising assistant prosecutors, John Baumel, to talk about officer-involved shootings. I did want to mention before we get started that there's potentially some imagery and some videos and some pictures which could potentially elicit an emotional response. So I just want to make sure that nothing graphic, but I want to make sure that everybody's prepared because we're going to be talking about some pretty intense subject matter. So without further ado, John, if you can join us. And what we've been doing, John, traditionally is just a quick little hello and maybe a description of what you do at the office and how long you've been at the office.
Sure, I will do that. Good evening, everybody. My name is John Baumel. Before I tell you a little bit about myself, I just want to tell you how impressed I am and really think it's great that everybody joins this academy, becomes a part of these sessions every week. You are people that are interested in becoming educated with what's going on in the community. You're people who are interested in the criminal justice system. And I think getting that information for yourselves is nothing but positive. And I think it's information that I would like to see everybody have. Criminal justice and crime and the court system is something that we see constantly in the media, whether it's the news, it's movies or books that you read, television shows. I always talk about when I'm in court and trying to let jurors know that what they're going to see is nothing like what they see on TV. I always reference the show CS. I always ask everybody if you're expecting for us to finish this up in 60 minutes, except for commercials in which you'll get to see the crime occur, the investigation, and ultimately, as in every CSI, they find the answer at the end, whether the person's guilty or not guilty. So unfortunately, the criminal justice system is vastly different from what you see on television. And so I commend all of you for being a part of this process. I've been a prosecutor for about 20 years now. I first became involved in it. I was in high school and went on a field trip. Grew up in Cleveland, went on a field trip and went to the courthouse, and we got to sit in on a rape trial in court, and just seeing the process, seeing the magnitude of the situation. At that point, I wanted to become a part of that, and I have. And although I didn't necessarily intend for it to be a career, it certainly has become one, and it's become a very rewarding career at that. Tonight's topic is, for me, is officer-involved shooting. I think this is about the third year I've been a presenter on this. I think I've been presenting 4 years. Again, we're doing it remotely or by video. First time I did it was in person. It was at the House of the Lord, and I had not been there before. It was my first time speaking at the academy, and when I went there, I was running late. And if you're familiar with the House of the Lord, it's gigantic and it has multiple entrances. And I went into one of the entrances thinking it was the academy because there was a little flyer on the window, and people were dressed up and there was food being served. And I thought, hey, this is nice, have a whole buffet. And I mentioned to one of the individuals, because I was running late, I said, I'm glad the show didn't start without me. Gave me a very strange look. And ultimately, I learned that I had walked into the reception of a funeral instead of the academy. And so they escorted me out of there and showed me where to go. But I'll never forget, that was my first introduction to the academy, was going to the wrong place. And I think that was the only time I've done it in person. So hopefully, again, someday we'll do that. I always feel a little bit funny staring into my laptop and talking and knowing the individuals are out there, but we've gotten used to it, doing it now as part of the court system as well. When we talk about officer-involved shooting, it can be a very emotional topic and can be a very tragic topic for those who are affected firsthand. And I have been involved in cases through the years of prosecuting police officers for a variety of offenses, be it drug offenses, theft offenses, gun offenses, sexual assault offenses. And it is never a part of my job that I've enjoyed, but it has been a part where I've tried to treat, and I think all prosecutors, at least good prosecutors, try to treat cases, whether it's officers involved or anyone else, try to treat it equally and objectively. I really have two goals in mind. One, determine if a crime was committed, regardless of race, creed, ethnicity, socioeconomic status, what their job is to objectively determine, has a crime been committed? And if so, number two, then what is the punishment? And then you can start looking a little bit more at the individual, what they've done in their lives, what kind of character they are, what good deeds or bad deeds have they done in trying to determine an appropriate sentence. And so, although this subject's a little different, that pretty much is the focus of my work, regardless of the case.
Hey, John. Hi, sorry about that. I didn't mean to interrupt, but I did want to remind people a couple of things. One, about questions, because I'm going to guess that people are going to have questions. Please put them in the chat room. I will do my best. I'm running John's PowerPoint, so I will look at the chat room as much as I can. But if you don't see your question being answered right away, or John, if you happen to see the chat and you want to answer a question right away, please go ahead. But I just want to let people know, please place your questions in the chat room, and I will bring them up as quickly as I can and run the PowerPoint as well. So just want to remind people that. Thanks, John.
Great, thanks, James. And I'm old school. I'm not. I'm still pretty inept when it comes to a lot of these systems. So, James, if there's something in the chat, make sure I take a look at it. I see it at the bottom of my screen. And anyone's having trouble hearing me? It's all broken up.
I hear you okay, John. There were a couple of moments where you did kind of break up a little bit, but I felt that everything seemed to be okay on my end. I'm not sure. Hopefully everybody else is the same.
Okay, well, I will try to speak up a little bit. I'm a little bit hoarse right now. But yeah, James, if I do break up, let me know so I can kind of go over some things and repeat myself. But I know that I'm in right now, there may be some internet connection problems, but hopefully we'll get through it with not too much freezing up and all that stuff. So when we talk about officer-involved shooting, unlike some of those cases I talked about, it's a little bit different because the officer-involved shootings always involve an officer on duty in the course of his or her work and in making split-second determinations that can affect lives. But is this screen up here now, James, the PowerPoint?
Yeah, it's up there. If you can see it, I'm on the second slide
okay.
Where it says prosecutor has to be an advocate.
Right. And this slide, I think last year when I had this slide, it was at the end, but this slide to me is everything. And and it holds extremely true when we talk about these officer-involved shootings. The prosecutor has to be an advocate for what is right. The prosecutor needs to make a very clear statement to the public that the incident is not going to be prejudged in any direction, that a full and comprehensive investigation is going to be done, and that when the prosecutor can be transparent about it, they will be transparent about it. And I think what holds true in this statement, one is that as prosecutors, in our cases, we have victims at times, but we don't represent the victim. we are in the rare position of representing the community. We represent the state of Ohio. We represent the community. And so because of that position, really, we are after the truth and we are after justice. That is what motivates us, and that is what our focus should be. But what's important in doing that is that the public is aware and has confidence in the decisions that we're making. And so the transparency, especially when it comes to these officer-involved shootings, the transparency is crucial for the public to have trust in the decisions that are making and in confidence that there's no bias, that there's no prejudice, and that ultimately when I say that a prosecutor is looking for the truth and for justice, that you as a community are convinced of that. So keeping that in mind, when I first did this presentation, these officer-involved shootings were a responsibility of the Summit County Prosecutor's Office, so that if there was an officer-involved shooting in which somebody either was seriously injured or killed, that it would be our responsibility to go out to the scene, to be involved in that investigation, and then to, along with the law enforcement agency investigating with it, help make a determination as to whether the shooting was justified, reasonable, and reasonable is going to be the key word as we go along here, whether the shooting was real, and as to whether any charges should be filed. So I could get a call in the middle of the night to go out to the scene. There was a protocol involved in that, in which when we would get out there, there would also be attorneys for the police union. So a police officer would be represented by attorney at the scene. We would go through the scene as to what occurred. Individuals would be interviewed and we would be present for that. And then ultimately, as time would go on, we would go through each and every piece of evidence, recordings, things of that nature. And as I said, make a recommendation in regards to how to handle the case. That has changed. Although I don't think I was ever part of an investigation in which I thought there was a bias or people showing, I guess a preference for one side. It makes total sense that now the Attorney General's office, the Ohio Attorney General, they handle these cases. We no longer are involved in going out to the scene and doing the investigation and in making any decisions. Rather, it's the Ohio Attorney General. The Ohio Attorney General as a whole law enforcement group. They have what they call the Officer Involved Critical Incident Response Team. They have a law enforcement group, not just for these cases, but they have them for all types of cases. Specifically, they have been focusing on officer-involved shootings. And so whether it occurs in Akron, if it occurs in Cuyahoga Falls, if it occurs, in Greene or Hudson or wherever it may occur, it is going to be the Ohio Attorney General's investigators from the Bureau of Criminal Identification who come out, do the investigation, and it's going to be their attorneys, their assistant, I don't believe they call themselves prosecutors, but it's going to be their legal team which makes the decision. And that's how it's been for the last several years. And first question right off the bat is, can they retroactively investigate an officer-involved shooting that was not previously? And I didn't get the rest of it. That's a good question. What I'm going to refer you to now as to how they handle cases is they have a full website. They have contact information, and as to they would be willing to go back and look at cases that were investigated by other agencies or that occurred prior to them taking over our cases. That's a possibility.
And we may have lost John. Let me see if he's still in the Zoom. So I apologize. It looks like we have lost him. But I believe that he was saying is that there is the potential that BCI could go back and review prior officer-involved use of force and officer-involved shootings, not just in Summit County, but in any county that they are tasked with that job. John had mentioned it's been several years. In fact, it was June of 2020 when Summit County Prosecutor Sherry Bevan Walsh, after some comments that were made publicly by Governor DeWine and Attorney General Yost, we decided that it would be best to have the Attorney General's office and the state's Bureau of Criminal Investigation, BCI, handle all officer use of deadly force and shootings in Summit County. Prior to June of 2020, the Summit County Prosecutor's Office had handled that. Like John said, we had a team of our supervising prosecutors who have, John's joining us back. I think I see John's camera back up and sitting back down. So John, I was just kind of tap dancing and filling in for you as you had your little technical difficulty. You're still on mute, by the way. So I was just mentioning about how, in fact, it was June of 2020 when we handed the use of force and use of deadly force and officer-involved shootings to the Attorney General's office.
I'm assuming that was just me who left the party?
Yeah, just you.
Okay.
We were hanging out. We were enjoying some quiet time.
I've switched rooms, so hopefully I have better connection in this room. I don't know, maybe it's the time of day that's caused it, but you know, as I was saying, let me get going on this PowerPoint. So the Ohio Attorney General's office has a website, and in that they talk about the fact that they have taken over these cases. They even have, you can download a book for free from them talking about the best practices for investigating an officer-involved critical incident. So you can fill out the information on the website, and there I have the website for you at the bottom, www.ohioattorneygeneral.gov/best practices. And you can get this entire book talking about the protocol that they follow in investigating these cases. And their websites emphasize, one, the appearance of objectivity, that they come in and do these cases, as opposed to, for example, Akron Police investigating Akron Police when there's an officer-involved shooting involving them. And they also talk about their desire to be transparent. And so if you go to the next slide, what you can do, and anyone can do this, is that they have their case files. So the officer-involved shootings that they've been involved in investigating, their case files are online, and you can go to that portion of the website, click on the case file, and you can read all about the case. You can read about the physical evidence that was found. You can read about the interviews. They're completely transparent in regards to what their investigation found. And to go back to how we did it in Summit up until 2020, is that we also issued a report. And so those reports were public record, and it was the same idea of trying to include all the information, all the different investigatory information that was gathered during the course of the case, interviews, the legal standards that are involved, and any conclusions that were made by the officers, as well as conclusions that were made by the prosecutor's office in applying the facts or the evidence to the law in the case. So what I'm going to do is try to go over the law. I'm going to refer you to a couple cases that I was involved in prior to 2020 to kind of show you how the law is applied to factual situations. Because this is such a national issue, whether it's George Floyd or it hit home here in Akron, Jayland Walker this summer, which is being investigated by the Attorney General's office now. These are issues that draw great interest and cause a lot of strong opinions. I'm going to present to you a couple of the national cases that were presented over the last several years, and then talk a little bit about what communities, what law enforcement agencies, legislatures, what people are trying to do to constantly make this a better situation. And when I say better situation, I mean that they are able to handle these cases in a way that they have the public trust, and also try to reduce these situations of police using deadly force, and seeing what is causing those type of situations and doing anything they can to fix that. So starting out with the law, and these decisions and what guides us, and this is what guides us as to how we evaluate the evidence and whether we think that charges should be brought, are all decisions that have been made by the United States Supreme Court over the years. And really what we're looking at is that police are not judged under a standard of what you or I would do under those situations. Rather, they are judged as how a police officer should handle a situation. And the question ultimately, the million-dollar question when I come down to it is, was the officer's conduct unreasonable? It doesn't have to necessarily have been the best decisions that were made. It can't be, well, he could have done this. Lots of times people say, well, why didn't he just shoot him in the leg? Things of that nature. The question is were they unreasonable in their conduct? And this comes all the way back from a 1989 case, Graham versus MS Connor, in which it said the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. Again, you're looking at an officer under the conditions at hand, under all the circumstances that they know at the time, and evaluating what we call the totality of the circumstances. In another US Supreme Court case, quote, with respect to the claim of excessive force, the same standard of reasonableness at the moment applies. Not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers. And so often, although, the analysis that we go through always comes, after the fact, what we try to do is not to be a Monday morning quarterback, but to try to evaluate the position of the officer at the time that the shooting or at the time that the force occurred, as opposed to after the fact. Again, case law from the US Supreme Court, the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The one, I guess, constant that I see in most of these cases is that there is a great level, almost an undescribable level of fear that is involved in these cases. It's fear of the individual who may be injured. It is fear of the police officer, either for himself or other officers or people in the community, but it's a great and intense level of fear people are making in the utmost of stressful situations. And so that has to be taken into account when we evaluate these situations on both sides. The person who was shot, how they acted, as well as the police officer. Next slide says the reasonableness of the use of force is evaluated under an objective inquiry that pays careful attention to the facts and circumstances of each case. So once again, we're looking at the totality of circumstances of each case It's never going to be just one fact. We're going to look at everything from the beginning to end. And the question again is, was the officer's conduct unreasonable under those circumstances? Right, next slide. Excessive force claims are evaluated for objective reasonableness based upon the information the officers had when the conduct occurred. And I'll go over that as we talk about some of the cases that I handled in the past. Next slide. Robert Talbert. So this is, I believe this is the last case that I handled back in August 11th of 2018, in which Robert Talbert ultimately was shot and killed by police after an investigation. And so I'm going to go through the facts of the case, what the police knew at the time, and ultimately how the shooting went down. And this all started early in the morning, 3:41 a.m., when Talbert shot and killed his ex-wife, his sister-in-law. So the sister of the victim called the police. In this police call, like a 911 call, she informed police that Talbert was bipolar, and also that Talbert, when he was in the house, and this occurred in the basement of the house. The sister-in-law was in the main level, I believe, of the house, or the second floor, and the killing occurred down in the basement. So she ran into Talbert before he left the house, although at the time she did not know specifically what he had done. But when she had contact with him, Talbert threatened to shoot himself and to police officers. And so this information is given to the police. And why is this important? Well, this is going to be, this information is going to be transmitted to all the police officers ultimately who start looking for Talbert, to know that he's dangerous, that he's armed, and that he has made those threats. And so that goes into when the officers take the conduct that they take, whether they were unreasonable. So the murder occurs at 3:41 a.m. At 6:30, it's reported that Talbert, oh no, I take that back. This was not information known at the time, but ultimately Talbert carjacked a victim at gunpoint and took an individual's car. And although this happened, the police were not aware of this. And so when we talk about the reasonableness, that would not be part of the equation, because none of the police officers knew that that occurred until after the fact. At 6:39, Talbert is on the run. He's looking for places to hide because he knows that he'll be wanted as a result of what he had done to his ex-wife. Talbert trespassed into a home, but the owner found him, confronted him, and Talbert fled. This was in fact reported to the police. At 9:09 a.m., Talbert trespassed into another home on Kohler Avenue in Akron. And that is ultimately the location where the police would find him at an intersection at Kohler Avenue. Next slide. So this is the scene at Kohler Avenue. And what you're looking at right now is a still shot from a body-worn camera. And what's, the body-worn cameras have been, a great source of information, truthful information, not only in these cases, but in all the cases that I deal with. When I have murder cases, when I have rape cases, body-worn cameras can take us all there to what the police see when they first arrive on the scene. And the way that body-worn cameras work, for those of you who may not be familiar with them, is that patrol officers are all equipped with body-worn cameras. The camera is on the front chest area of their police uniform. When police cruiser lights are activated, that will also activate the camera. Police officers also have the ability to activate the camera themselves. Once it's activated, the camera actually is always taping. So it goes back 30 seconds prior to being activated. So you can see 30 seconds prior to either the siren on a police cruiser being activated, or if the police officer activated his camera himself, it goes back 30 seconds. It won't have volume for those 30 seconds, but you'll see video for 30 seconds and then the volume will join in. But these body-worn cameras first came into play because of complaints against police officers in regards to their conduct. And not only does this serve the public, that you get to see firsthand what is occurring, but it also helps the officers to justify their conduct. At times there can be false allegations against the police, or there can be explanations for what went on. James, can you go back one slide? All right, so this is the house on the left, the kind of the blue house with the big windowed in porch is ultimately where Talbert went into the house. He was actually familiar with the residents, not very familiar, but he went inside. He ran into the homeowner knew him, but the homeowner at that point didn't know him well enough that Talbert should be inside his residence. So he called the police. Police then knew that Talbert was at the residence. They walked into it. Talbert then walked out the front of the residence and would be in the intersection then at that point. If you look at the house on the right, kind of the lighter colored house, you'll see a cement stairway. And the two police officers who were involved in the shooting, they positioned themselves behind that cement stairway. They took cover there so that they could still see the intersection. They could see Talbert, but they would be concealed somewhat behind the cement stairway. So if we go to the next slide, now you see the position of the officers. They're behind that cement stairway. They can look out into the street, and it's a small figure. The next slide will show it kind of enlarged, but that's where Talbert stood. And in his left hand, he had a handgun, and he had the handgun pointed at his head. Keep in mind, this is at about, if I recall correctly, around 10:30 or 11 on a Saturday morning. These are streets where cars are driving by, kids could be riding their bicycles by in this neighborhood. It's a total residential neighborhood. People could be walking totally unaware of what's going on because this is really kind of happening quickly. So there's not time to block off roads or anything like that. But this is what the officers are seeing from behind those cement stairs. They're seeing Talbert with a gun pointed at his head. Next slide. Well, I'll tell you what happened next then. As Talbert started moving the gun downward, police were yelling over and over again to drop the gun, drop the weapon. On the body-worn cameras, you could hear them yell, drop the weapon at least 10 to 12 times. He ignored that, and when he slowly started moving the gun downward is when the officer shot. And so because of statements that he had made, because he had already committed a homicide earlier that morning, because he was continuing to break the law, and because at this point, most importantly, he had a gun, was unwilling to drop it, and he's in the middle of a community at 11 o'clock on a Saturday morning, police officers were not unreasonable in fearing for their safety and fearing for the other officer's safety, and really fearing for the community, not knowing who might drive by, who might walk by, who might ride by on a bicycle at any moment. And when Talbert refused to drop the gun and in fact started lowering it, the possibilities of what he was going to do were too dangerous at that point. So that shooting was determined to be not unreasonable, and the criminal charges were not pursued. Another case that I handled back February 2018, and this one was a very unusual type of case. This was a case involving the Lakemore Police Department and Springfield Township Police Department. Christian Beard and Matthew Burkhart were in a van, and they had gone to a strip mall, and this is kind of an overhead view. The right side is the strip mall. There's a Tractor Supply at that strip mall, and Tractor Supply, kind of like Lowe's or Home Depot, at that time they would keep a lot of their merchandise outside in front of the store. They would keep it chained up or locked up at night, but it still was outside in front of the store. And these two individuals in their van pulled up during the early morning hours when the store was closed, when nobody else was around. And they tried to steal some of the items that were out in front of the store. If you can go back still. They were unsuccessful, and in fact, there were people working inside Tractor Supply who called the police. And so this is kind of like a back exit from the strip mall that you can see in that picture, the long driveway. And so they were unsuccessful in stealing anything. Police had been called, and as they pulled out of the driveway, they turned to the right, and they decided to pull into the U-shaped driveway of it was a triplex there. So kind of three apartments were located there, and they stopped the car there in the middle of that driveway. The complex, or this triplex, had security cameras. So we would have video of them pulling up, stopping the car, turning off their lights, and parking in the driveway. Now, whether they did that just to avoid police detection because they turned off all their lights, I don't know. But the police, it didn't take them long to locate the van, which had been identified from the 911 caller in that driveway. So next slide. So at this point, this is a view of the security camera from the triplex. You can see the van. At this point, the police have shown up, and the SUV police cruiser parked in front of the van. As I stated, when they pulled up, the lights were off, the engine was off. But because the van matched the description, they decided to go and investigate. Next slide. And so you can see the police out front, police in front. And there was even a police car in the rear of the van. And sure enough, when they went into the van, they saw the two individuals there. Police knocked on the window, trying to get them to come out of the van. However, both of the individuals had their eyes closed and pretended like they were asleep. And no matter how hard the police officers knocked on the window, the individuals in the van refused to respond. So one of the police officers, asked for a device to open the locked door. And it was in the process of opening the door that the occupant in the driver's side opened his eyes. Next slide. Again, this is from the body-worn camera of the police. And it was after being in the process of opening the unlocked door that this individual opened his eyes. They started demanding that he open the door. However, instead of opening the door, he decided to start the engine of his car and decided to pull away. So he first, because he was kind of trapped in by the vehicles, including the police car behind him, he rear-ended the police car. And as the police officers who had been outside of their cruisers saw this, they started to run to their police cruisers. But in doing so, this van started then swerving because it had nowhere to go initially. when it was going backwards, the tires are peeling, but it was able to get out. And at that point, the van is facing one of the police officers and starting to approach one of the police officers. And it was at that time that two of the police officers saw that and opened fire on the van, seeing that the van was running and was going forward and was going directly towards their fellow police officer. Next slide. And that's kind of, it's a little bit of a blurred view of what was going on there, but you can see all the smoke is from the tires just peeling because it's going backwards into the police cruiser and not getting anywhere. And you can see a police officer, two police officers that are somewhat in front of that van. And as the van turned, it was directly facing the officers. Next slide. That's a different shot. That's a shot from the security video. You can see a figure of the police officer. You can see one police officer closer to the street who was running towards his police cruiser. You can see a police officer who's closer to the vehicles in a position of his arms forward with his firearm, and he was shooting at the van. Both individuals inside the van were hit. The van did not get away, but because, once again, the totality of the circumstances in this case, that being that these individuals, one, they had tried to elude police after committing a crime, that instead of complying with the police officers to open the door, the driver did the exact opposite, kept the door locked, started the engine and started moving the van. And then at the point where the van was facing directly at one of the officers and started going forward, that it was determined not to be unreasonable for the other police officers to start firing at the driver of that van so that the van could not harm the police officer. And once again, this was investigated by the Ohio Attorney General's office, specifically the Bureau of Criminal Investigation. And we had multiple videos. We had the body-worn cameras. We had the video from the house. And they enhanced the videos. We took it slide by slide to see step by step what had occurred as far as when the van started, when the van started going backwards, when the van started going forwards, and when the individuals, the police officers first fired their weapons. There was volume in the case. And sometimes these cases become even more tricky when you have multiple police officers there, and some officers fire their weapons and others do not. Because obviously the ones who do not, we have to try to determine why didn't they fire their weapons? Is it because they were under a different circumstance? Why did they feel that firing a weapon was not necessary at that point? And so all these individuals are interviewed. In this case, the one officer who didn't fire his weapon, it's because, as you can see, he was running with his back to the van, and it was his intent to go to his cruiser. And if that vehicle got away, he would be able to pursue it in his vehicle. I see in the chat, how valuable is that testimony on why the others didn't fire? I mean, it is valuable because, once again, we are looking at how a reasonable officer would act in the situation, an objective officer. And so not only does it become important as to why other officers didn't shoot, but it becomes important that the officer who's investigating this provides insight in regards to police training. How are they trained to react in these situations, and how other police officers would act. So it becomes important, but once again, that is not the only determining factor. That's a factor. But as I said earlier, a police officer might have multiple options. They might have option A, B, and C. And because officer chose option A and we think B was a better option, that does not necessarily make it a crime. We focus once again on option A, and was that option unreasonable? Because, unfortunately, it's a split-second decision, and we're looking, were they unreasonable in choosing the path that they chose? Because maybe another officer chose a different path, that doesn't make it necessarily criminal or unreasonable under the circumstances. But it is a factor, and it can be an important one based upon the circumstances. Someone also in the chat mentioned just downloaded the ebook from the previous slide. Quick and easy, and you can get in this. Yeah, so that I would recommend, if you have a real interest in this, that ebook. It was written by a Mark Kohler, who's one of their lead investigators. I worked with him. We had a serial killer known as the Craigslist killer in Summit County, as well as down south, and he was the lead investigator on that. And he's meticulous. He's very fair. He's very by the book. He's very intelligent, and I think he has done a great number of these cases. And that book was written by him in regards to the protocol that they utilize in investigating these cases. So as I said, this case took a while to actually deliver a report because of all the technology involved and wanting to get it right. There was methamphetamines in the car. There was a lot of evidence that both these individuals were on meth at the time. Although the police officers didn't know that provided insight as to why, that driver didn't just simply open the door and allow the police officers to inquire and find out the reason they were in that drive. All right, next slide. All right. So those are two cases of that I was directly involved in, finding that the officers' actions were not unreasonable. Most, if not everybody, is aware of George Floyd Jr. and the incident that occurred back in May of 2020, in which the one officer's knee was placed on George Floyd's neck during the course of his apprehension and detention. And I think at the time, the amount of time that knee remained on his neck was anywhere between 7 minutes and 46 seconds to 9 minutes and 30 seconds. Once again, I give great deference to how prosecutors handle those cases, because although we get to see videos and we get a little bit of information here and there, really, there's a lot of information that the public never hears through the media, which can be crucial in making those decisions. Obviously, in that case, prosecutors decided to bring charges not only against the officer whose knee was on George Floyd's neck, but the others as well, which have resulted in convictions. And the type of case that that we try to model our investigations after, and try to make decisions once again transparently so that everyone can see it and hopefully make a decision that is the correct decision. Question was, have you ever handled an incident? Have you ever handled an incident where the officer shot and killed a subject that was not armed with a firearm, car, or other dangerous ordinance? I have not. I think I did about a half dozen of these, and I had one where an individual had a knife going at the police. There was an individual who had pulled over by a post office in Akron, and he had what appeared to be a gun, but it was in fact one of these BB guns that looked almost exactly like a semi-automatic, which he had reached for and had started directing it towards the police when the police shot and killed him. That was an individual we then learned from family members that he had said that he would never go back to jail, that they would have to kill him, and that ultimately, he told family members that if he ever did get pulled over, he would die with suicide by police. But I have not had a case where the police where the individuals did not have a deadly weapon. I know there've been cases, and one of the cases we're about to watch, I think this first one, Stephen Clark, involves where police believe.
Now to Northern California, where there is growing outrage over a fatal police shooting. Officers opening fire on.
Sorry, John, the video started on its own, so I apologize for that. Do you want me to play it?
Well, let me just give a quick introduction. This is a case where the individual had a cell phone, although police thought it was a firearm. This was March 18th, 2018. Stephen Clark was shot and killed in his grandmother's backyard in Sacramento, California. 2 officers fired at Clark, who had a cell phone in his hand. Police video cameras captured the shooting along with a helicopter. The officers fired 20 rounds. He was struck 7 times. So yeah, if you would, James, then play the video.
Now to Northern California, where there is
only play you can stop it at the 4-minute mark.
Now to Northern California, where there is growing outrage over a fatal police shooting. Officers opening fire on an unarmed black man in his grandparents' backyard. And we are now getting our first look at that shooting. Police apparently thinking he was holding a gun, now say it was a cell phone. NBC's Gadi Schwartz has our report from Sacramento, and we want to warn you the video you're about to see is disturbing.
Just broke the window, running south, running to the south.
Officers in a chopper investigating reports of a man vandalizing cars, saying they have a visual on the suspect.
All I can tell is he's got a hoodie on.
A heat signature from the police helicopter camera, the first glimpse of 22-year-old Stephen Clark.
Okay, let's get a perimeter on this guy's running.
2 officers below close in.
Stop!
And here is the moment of contact on the ground.
Show me your hands, gun!
In the dark, an officer yells gun.
Show me your hands, gun, gun, gun!
Police firing 20 shots at Clark in his grandparents' backyard, finding no weapons, only a cell phone. Minutes later, one officer says mute, and the 2 cameras stop recording audio. Clark's family wants to know exactly what was said.
You're muting something you don't want the public to hear what you're saying. And that means that if you don't want the truth to come out, then all of it is a lie.
Sacramento Police Chief Daniel Hahn.
When you saw them turn off the audio there in that clip, what did you think?
I'm just curious why they did that. But I knew that was part of the investigation.
Sacramento has been criticized over use of force against black men in the past. Police confirming in this shooting, one of the officers who opened fire was also black.
Things are heated right now.
It gets
People are
difficult,
angry and hurting and all those sort of things. And I just don't want anybody else to get hurt in our community while we're going through this investigation.
But even with transparency, tonight, a community's frustration still grows. Gadi Schwartz, NBC News, Sacramento.
Hey, NBC News fans, thanks for checking out.
All right. And in that case, that was in Sacramento. The Sacramento district attorney announced there would be no charges. She found the officers had probable cause to stop him and were legally justified in the use of deadly force. Federal authorities also indicated they weren't going to file any civil rights violations, and so nothing happened to those officers. Again, it can be a tricky question, but the question is, was the officer's actions unreasonable? And in that case, that prosecutor's office deemed that it was not and didn't bring charges. Next slide. And I know I'm running a little bit late here, so I'm not going to play this. Samuel Dubose is a case from Cincinnati, and it was a case where an individual it was a traffic stop, and the individual drove away from the police officer, and the police officer shot 1 time, struck and killed him. There was no weapon. Really, you know, once again, I try not to make any kind of opinions based upon just what you see on TV because there's so much more to it. But in that case, the individual was prosecuted, the officer, because he had lied about the situation. The body-worn camera showed something different than what he said. And it also appeared to be totally unreasonable. However, when it got to trial, first time he went to trial, a jury, you need all 12 jurors to be unanimous. They were not. They were a hung jury because they couldn't all agree. They tried the officer a second time. That was a hung jury as well. And so they did not to try him a third time because they felt they could not get a unanimous jury. And so there was an attempt to hold that officer responsible and it didn't happen. So, all right, I think I've gone over my time, but I do want to stress, you know, what communities are doing. They're trying to do it here in Akron. I think they're trying to do it in other parts of the country as well. And that's to try to bring together the different parties, be it law enforcement, be it individuals in the community, be it family members or people themselves who were shot, be it religious leaders, to try to come to an understanding. Because like I said, a big part of these cases are based upon a fear and an inability to understand the intent of the other party. And I think bringing the community together to get both sides to understand where they're coming from, their situations can only help. There's also a lot of programs, more programs being utilized by police agencies to really focus hard, and I mean focus hard on de-escalation. That when a situation is getting tense, to have officers fully trained on de-escalating the situation and doing whatever they can to avoid getting to a point where they feel the need that deadly force is necessary. All right, I have one last question. Who decides when the cameras are turned off, and can an officer refuse to shut his off if he doesn't think it is appropriate? Usually, so the cameras most times go on automatically when the police, you know, activate their cruisers. They can turn them off, but there is specific policy, and it ranges from agency to agency as to when they're permitted to turn the volume off, when they're permitted to turn the camera off. And as I said earlier, for the most part, having that camera on and having the volume on benefits everybody because that shows the truth of what occurs. There are times where turning the volume off makes sense because they start talking about theories as to what occurred. And in my criminal cases, you know, sometimes what a police officer first may have a theory or an idea of what happened, turns out not to be true, and it was only a guess. And those aren't, you know, those aren't things that should come into court. But for the most part, there are policies, there are procedures, and officers can get in trouble and do get in trouble if they're not following those policy and procedures. So,
I took down the PowerPoint because I didn't know, John, if you want to continue through it, we can go through it. We're just going to be a little over on time tonight.
yeah, I mean,
we can continue doing that. That's why I took it down. There's also another question in the chat, John.
well, let me say this for both the PowerPoint, you know, and what we do. Do they have access to ask us questions or contact us by email, James?
Right. We've mentioned many times that if there are any questions or further conversations, to email either Tanya or myself, and to be able to do that. But I didn't want to stop you, but I just wanted to kind of see where you wanted to go, John. That's all.
Yeah. Well, I'm 15 minutes over. I didn't realize it would go that long. Next year, I'll ask for more time. But if you want, you can email questions and I'll respond in writing. If you want a copy of that PowerPoint, by all means, we'll provide you with a copy of the PowerPoint. Like I said, I'm 15 minutes over, so I'm gonna let the next speak or go, but don't hesitate to email questions, or if there's questions on here, James, if we can get them down, and I'll respond in writing to those questions.
Yeah, we can do that. That's fine. No, I apologize. I know there's a lot of interest in this topic. I didn't want to stop you, John, but I did want to at least, be respectful of people's times. But yeah, like John said, you have Tanya's email, you have my email. If there are any other additional questions, we'd be happy to answer them now, or we can accept them at any time. So John, I appreciate it. Thank you for your time and your thoughtfulness in your presentation.
All right. Thank you to everybody. I appreciate it. I appreciate everybody being here and showing your interest in these subjects. They're very important.
So we'll move on then. We have a very interesting and important presentation from our Child Support Enforcement Agency, which the Summit County Prosecutor's Office oversees. Shelley Woodruff from our Child Support Enforcement Agency is here and to do our presentation. Shelley, what we've been doing is just a very quick little kind of explanation of who you are and what you do with the office. And then I will put up your PowerPoint and we can move on.
Okay, sounds good. Good evening, everyone. I am Shelley Woodruff, and I am our Community Relations Specialist with the Summit County Prosecutor's Office. I work in the Child Support Division, and I have been a part of this agency for a little over 23 years. And so I know a lot about child support. I've been a caseworker previously. I've been in, I've also done like our establishment. There's not very many jobs at our agency that I have not had the privilege of doing. But currently I'm the Community Relations Specialist. So I am out in the community. If we're having an event or if we are participating in an event, then I am possibly the person that you will see at that event. I am in the prisons. I deal very close with anyone that is currently in prison and housed in a facility. We do classes with them so that we can work on their child support cases and try to still give them the services that they need while they're incarcerated. I also work with our Oriana House programs. I work with some of our Akron Public School programs that have parents. I work very closely in the community with our hospitals to establish fraternity. So I wear a few different hats, as well as I'm a big part of any of the like open M events that we do out in the community where we serve hot lunches and things like that. So some of you may know me. Some of you may have actually spoken to me or maybe attended an event where I had some giveaways. Some of you may have come across me, just at different events because I'm usually out in the community. Of course, pre-COVID, before COVID hit, I was a little bit of everywhere, just about every single week. I was all over the place. So not so much anymore, but I'm still, you still can reach me. My phone number and my contact information rings directly to my phone. I can, help you with just about anything that you would need help with. So we're going to go ahead and get started with the presentation. And I'm just going to kind of give you guys just like a brief PowerPoint presentation. And if you have some questions, that's fine. Please don't hesitate to ask. If it's something that I don't know the answer to, which usually doesn't happen very often, then I will be sure to get the answer for you and get back to you. So let's go ahead and get started. So we are the Summit County Child Support Enforcement Agency. That's what the CSEA stands for. We have over 51,000 children in our system that has cases. So with the 51,000 children, we can have multiple children on one case. We can have one individual child on a case, but on each and every case, there's always two parents, whether it's a caretaker and a non-custodial parent, mom or dad, or whether it's a custodial parent, mom, or custodial parent, dad, and a non-custodial, the other parent. But we always have two parents on each case, even if it's a caretaker case. So we have 71.4% of child support owed is collected in the month that it is due. So that means every single month, if a person is ordered to pay child support, for instance, $100 a month, on the first of every month, that case would charge that $100 plus the 2% processing fee. And once that case charges the $100, this 71.4% is saying that 71% of those cases actually receive that full $100 in that month that it's due. So it's just saying that it is collected in the month that it's due. So every case is open and that charge is sitting there for that 30 or 31 days or 28 days if it's February. But the entire month, that case is there and the payment for the current month is due, and it's usually paid 71%. In the federal fiscal year 2022, parents paid over $44 million on time. So that's huge, because I know, you probably hear a lot about deadbeat moms, deadbeat dads, or whatever the case may be. But as you can see, these are the numbers, and the numbers don't lie. So, 44 million parents are paying on time, so within their 30 days that their case is charging. And then in the federal fiscal year 2022, parents paid over $17.4 million towards past due child support obligations. So that means that we had $17.4 million was paid. That went towards past due child support. So that means, for instance, that $100 that I just mentioned, if that full monthly obligation of $100 is not paid by the last day, the last business day of that month, then it goes into what we call arrears, which is past due child support. And so a lot of the cases that we have that are older, there's child support arrears or past due child support sitting there. The children are now grown. The child support never goes away until it's paid. And so, we are still collecting on those cases. Next slide. Okay, so Summit County CSEA, what are the benefits of child support? So the main benefit of child support is so that both parties are responsible financially for providing for that child. Child support is not to help mom or dad or whoever the custodial parent is, have a lavish lifestyle. It's to help support or make sure that that child has everything that they need moving forward. So there's, quite a few benefits to the having a child support case. Who is eligible to apply for child support services? Any parent can apply for child support services. Any alleged parent, meaning that paternity is not established, any legal custodial parent can apply. There's no income eligibility required for Title 4D child support services. Parents who receive cash public assistance are required to cooperate with establishing paternity and enforcing and establishing a support order against a non-custodial parent. In addition, court orders must include a requirement that support orders must be paid through CSEA. The only exception to this is spousal support. And spousal support is different. They have to do a different 4D application for a spousal support case because there's no children in that case. But the cost of the service is a totally free service, from establishing paternity to establishing a support order to enforcing the order. There's no cost for the parent to apply for our service and get those services. Okay. And then the services provided when the parents are living apart. So we have establishing paternity is a legal parent-child relationship. So establishing paternity is whenever the parties are not married. Okay. In Ohio and every other state, if parties are married and they have a child, even if the husband is not the biological father, there is a presumption that because they are legally married, that the husband is the father, unless proved otherwise. So any child that is born to parents that are not married, paternity needs to be established. And then we're going to talk about how paternity is established so that everyone understands how paternity is legally established. So, we establish paternity, then we establish a financial or medical support order. We are responsible for collecting the family support obligation and dispersing that to the family. We also modify the orders. We review them and we modify the judicial and administrative orders if they meet certain qualifications. And we're going to talk briefly about that as well, so you all know what needs to happen in order to request modification. We locate parents. So in some cases, we may have a custodial parent who has the child and they want to establish paternity so that they can have a support order. So then we have to locate that other parent so that we can legally establish paternity and then move forward with establishing a support order. Also, we have the non-custodial parent sometimes contacting us and completing an application for services because they want to start a case so that they can get location on the parent or the child to try to find out, where they are so that they can legally establish paternity as well. We also enforce the family support order. So that's our responsibility to make sure that when there is a child support order in place, that we are enforcing those orders. Okay, what if one parent lives in another state or country? Each state and territory of the United States uses the same law to process intergovernmental cases. The CSEA can provide assistance with establishing, modifying, and enforcing support orders, even when one parent lives in a different state or a different country. So we actually have in Summit County a unit that is called our interstate unit. And that interstate unit, they only work with cases where one or both of the parties now are out of the state of Ohio. And that's all the cases that they have in their caseload. They're strictly interstate cases. And we are either enforcing another state's order, or we are either collecting on another state's order. So those are those interstate cases. Options to establish paternity. So the establishment process, I know everybody has probably heard of DNA testing, or if if you're my age, you remember the Maury Povich show, which still comes on, and a lot of those shows are DNA shows. But establishing paternity by DNA, which is a buccal swab on the inside of the jaw to swab the DNA markers, that is one way of establishing paternity. In the 23, almost 24 years that I've been with the agency, I worked a lot of my case management position in establishment. So that was kind of like what I did. I was all about locating a parent and getting paternity legally established for a child, so that child has a mother and a father, and have them on record that is their biological father and that's their mom. But the benefits to establishing paternity, which it's sad to say that we're kind of dealing with a lot of these situations. We know mom is mom, and that is the reason why mom normally is considered our custodial parent, because when the case first starts or it's created, then typically it's either from mom signing up to receive some type of assistance, or her, asking for our services to establish paternity, to have dad's name put on the baby's birth certificate, and then to have a support order. But we have probably about 35% of our cases where we have custodial parent dads. And dads have custody of the children. The children are living with dad, and they want to establish a support order for the other parent to pay. So, paternity establishment is very important, and nothing can happen without paternity establishment being done first. So as I said, we have the buccal swab, which is the DNA test. Besides the DNA test, we also have the paternity affidavit. It is a brown form that is available at the birthing facilities or hospitals, and it's also available at the Vital Statistic office on Market Street here in Akron. But the paternity acknowledgement is a form that must be signed by mom, it must be signed by dad, and then it has to be notarized. Both signatures have to be notarized, and it has some very small writing on the back of it. And when I was in the hospitals and I was doing paternity acknowledgements, I always explained what they were signing, because some people just think, hey, it's just me putting my name on the birth certificate. But why would you want to put your name on a birth certificate and you have doubt as to whether you're dad? Or why put your name on a birth certificate if you're not sure whether you're dad? I always used to explain to our parties that once you sign that Brown affidavit, which became effective January 1 of 1998, once you sign that Brown form, that affidavit, then you have 60 days from the signature date, the last signature date on that paper, to ask for a paternity test and say, hey, I want to rescind my signature, and now I want to do a paternity test so I can be sure that I am dad. Or mom can say, I want him to take a test so he can see that he's dad. I don't want him to sign this form, or I don't want this form to be valid. So you have 60 days from the date that that's signed. And then paternity, as I said, can be established with a married, if there is a couple that is married and they're legally married, then paternity is presumed to be established. And then the other way of establishing paternity is by a default judgment. So what a default judgment is anytime we have a case and we are trying to establish paternity with the parties, then if we have a parent that does not show up for DNA testing, then we can move forward with dismissing our action for paternity establishment by DNA testing and file a motion to move forward with it through the courts, because the party will not cooperate with appearing to have their mouth swabbed. We schedule appointments for DNA testing twice, in most cases a third time, to allow all parties to show up. And if a party does not show up, then we dismiss the action and we send it over so that the court can move forward with what will happen next. But that is typically a default judgment. A default judgment typically would allow a mom to swear that this is the only possible father, and he won't cooperate for DNA testing to prove that he's dad or that he's not dad. And we go to court, file a motion. He served, she served, they appear in court. And then at that time, a judge will ask if he wants to take paternity test. And if he says yes, then they will then order a fourth paternity test. If he doesn't show up, then they use her testimony and they default him as dad based off of her testimony. Now, I have told people in my long time of being here, you don't want to be in that situation. I had a phone call just Monday with a young man who says, well, if I don't show up, you can't prove that I'm dad. And I said, well, I'm not sure who told you that, but that's not the truth. He says, well, I'm not the dad. I said, okay, if you're not dad, show up. Have a paternity test done. You're going to be excluded. There's no way to get a false positive. He's scheduled for tomorrow. I will see if he shows up. But as I explained to him, I took extra time to explain to him, hey, listen, this is what's going to happen if you don't show up. So I get it. You're saying you're not dad. You don't want to be bothered with this. This isn't what you signed up for. I got it. I get all of that. However, with that being said, once you're named as a punitive parent father, then we have to test and exclude you in order for this to go away. So it's very important that if you guys know anyone, or if you have ever received a notice to appear for DNA testing, that you appear for DNA testing, because it doesn't go away, and the courts can default or deem that person as dad without doing a paternity test based off of non-cooperation. So it's important that you know that. Okay, let's see. Financial support. The best way of us collecting child support is with an income withholding order. So that means that's an order that goes to the employer of the person that is ordered to pay the child support, it goes to their employer, and then the employer starts to withhold based off of that ordered amount. And that's taken weekly, bi-weekly, or however that, if they're paid once a month, then that's how it's taken. But that's completely up to the employer as to how payroll works with that employer. So most of our cases that have support orders, we try to do the income withholding. Administrative remedies that we use to make sure that we're doing our job. We have something that's called lump sum orders. That's where we can intercept a lump sum if someone is behind on their child support and they're due to get $150 bonus or something of that sort. We can intercept that and apply that to their child support case. We have the default action. Whenever a support order falls behind, it falls into default and it's in default more than 2 months, then we can default that case, and that means we add an additional 20% to the monthly obligation to try to catch up with the arrears that's fallen behind. We also have federal and state tax refund offset programs. So whenever a person owes child support, depending on the amount of child support that they owe, they will receive a notice typically in about September of the year, anywhere from the beginning to the mid part of September of that year. Then we send the computer generated offset letters go out in the mail to tell parties, this is what you owe. If you don't pay this and this is not paid by the time you file your income taxes, then your income taxes can and will be intercepted. Again, it just depends on whether it's state or whether it's federal. It depends on the amount. We also file liens. We can file liens on your property and things like that. When you're not paying your child support, then they can file a lien against the property. We do suspend driver's license. I know people will say, well, why would you suspend a person's driver's license if they're not paying their child support? We have tried to do other measures to avoid suspension. Communication is the key. Any of the clients that I've come across, and most of the clients that I deal with, they're either in some kind of programming or incarcerated. Communication is the key. If I know something's going on and you're in programming and you're trying to better yourself, then I'm not going to request for a license suspension. If you are, just not paying your child support and, you've made it clear you're not going to pay your child support, the issue is, as an enforcement agency, I have to enforce this case. And the thing people fail to realize is that when one party, is owed the support, they want their support. And if they don't get their support, then they're calling because they want enforcement on their support. And then the other party who's not paying due to whatever reason, we send the notice out to tell you that your license is going to be suspended, that you have so many days to contact us to avoid that from happening. I don't know that if someone contacts us and say, hey, I am interviewing on a job, just allow me another 30 days. Please don't suspend, don't suspend my driver's license. Give me a chance. I don't know that we won't work with them to do that. In my current position, I've reinstated driver's license often because the only thing you have to do in order to get your driver's license reinstated is either call me with the name of an employer, or if you're in a situation financially come into some money, you can pay your 3 months of support. But typically we're not turning down money because the custodial parent with that child may need that money. So we're going to do whatever we can to work with the person to try to get some form of payment to go towards that case so we can avoid that suspension. But again, driving a car is a privilege. So if you're not driving to go find a job or go to work, then why should you have that privilege? But the other measures is the financial institution data match. That's a reporting system that reports employment information to us. Lottery, gambling, prize award interceptions, we can intercept lottery. If you win at the casino, we can intercept it because it's all up under your social security number. insurance claims interception. So if a person is in a car accident and they're behind on their child support, we can file a lump sum notice to intercept money that they would be paid from a car accident. And then our QuadroPro, those are different reports that we work at our agency to try to make sure that we are giving the services to our custodial parents and our non-custodial parents, because there's several reports that's worked up underneath that. Judicial, our ways of judicial is the contempt action. In the event that somebody's not paying their child support and they haven't for a period of time, we can file a contempt against them to get them in front of a judge to explain to the judge why they're not paying their child support, because it's a crime not to pay your child support. It's a court order. And once a court order is set, you're obligated to pay that support order unless, you know, courts have issued an additional order. So we can file contempt actions. We also have criminal actions, and criminal actions is non-support of a child. Typically, when a person is taken for a criminal non-support, they end up with a felony 4 or a felony 5 on their record, and then they're usually either entered into some type of work program where they'll go to like an Oriana House facility, and after 30 days, they have to find a job in order to get out and, you know, be in compliance. So those are some of the actions that we use at our agency. Let's see what's next. Okay, working with parents to remove barriers. So as I just talked about as I just talked about the suspending of the driver's license, we have a number of programs in place. So if you hear people say, you know, they suspended my driver's license, they're not doing anything to help me, I'm a convicted felon, I can't get a job, just, you know, all of these excuses, we actually have programs that are available through our office for no cost to anyone. We have a very, very successful program called Family Support Matters. And Family Support Matters, you know, they work on several different things, but the most important is they work on job readiness. And we have a list of employers that work with us, and they have, you know, if someone has a barrier, they will work with us. They will hire them. They will bring them in. If they want to work, they're going to put them to work. And so we do have services. We have a lady, Lisa Dolan, that does our Family Support Matters program. And, you know, all it takes is a phone call, enter into her program. If someone has a suspended driver's license, they sign up for the Family Support Matters program, then typically we will reinstate their driver's license to allow them to job search and to, you know, go to these classes and get job placement and be legal to do that. We don't want to see anybody get in trouble for driving with a, you know, suspended driver's license. So we do have programs in place. We have our forgiveness of state owed arrears. We have several cases where, you know, custodial parents are not owed the money. The state of Ohio is owed the money because the custodial parent was receiving some type of cash grant or benefit from the state of Ohio, and the arrears are not owed to the custodial parent. They're owed to the state of Ohio. So we've had cases where, you know, people have owed $15,000 and they've been incarcerated, the money is owed to the state, and then we can allow them to apply for forgiveness of the state owed arrears. They may have to pay a small portion of it, or they may, in some cases, be forgiven for the entire amount because it's money owed to the state. And then communication. We have a number of programs that we work with. I myself work with one of our state office fatherhood groups. And so we are always trying to help. We're always trying to, you know, put somebody with a fatherhood group that can help them with employment. We have expungement clinics. We're a part of all of those events in the community to try to help make sure that we are helping parents that have barriers get the barriers removed so that they are in compliance. We talked about license. Well, I talked about license suspension. I talked about how can parents avoid a license suspension. Communication is going to be the key. You know, we're going to document that case that we spoke to the custodial parent, we spoke to the non-custodial parent. we're going to give them 30 days to, try to make some form of a payment. Again, some payment is better than no payment at all, because in most situations, the custodial parent may need that money. And, we don't want to, if somebody says, hey, my order is $200, but I only have $100, absolutely, we're going to accept that $100 and we're going to send that out to the family. And we're going to work with that person to see if there's a way that, they can come up with that other $100, or, if we can document it and put them in one of our programs to help them with job placement or something of that sort. How can parents get their driver's license back? I talked about that already. Calculating child support. So calculating child support is not an easy task. You can see here, this is the calculating child support, the Ohio Revised Code, section 3119, income shares model. So both parents' income and other information are used to develop support obligations that represent the combined resources available for the support of their children. So basically that means when a support order is set, both parties' income is taken into consideration, because if the parties were still together, that child would benefit from both parties' income. So when we set a support order, it's based off of bringing in mom's income, bringing in dad's income. And then of course, other things go into play. If mom has other children, if dad has other children, if dad is disabled, or if mom is disabled, like every case is different, but this is our general income shares model. There's a worksheet. We look at the gross income, the adjustments to the income, such as if either parent had another child that lives with them or that they're responsible for, you're going to get credit for those other children that you also take care of. Income shares, we're going to bring in both incomes. Support calculations, we're going to run the guidelines, and then the guidelines is going to generate an amount based off a percentage from mom and a percentage from dad. And also cash medical. Cash medical is where if the parties do not have private medical insurance available to them, they usually end up with a cash medical order, which is an additional payment towards the medical for that child. In those cases, some of those cases, they're receiving medical from the state of Ohio. And so that portion could be that medical amount could end up going back to the state of Ohio. And then recommended monthly orders for decree. Somebody's unmute. Oh, there we go. Recommended monthly orders for decree. So those are our child support orders that may come over from the courts from a divorce or a change of custody or something of that nature. Termination of support. So I'm not going to read this, but termination of support is where our child support order can be terminated. Okay, there are certain reasons that we are allowed to terminate child support orders. So I'm just going to tell you those reasons, because I realize that writing is very, very small. So an order can be terminated because the child has passed away. If the child is underage and was permitted to get married, we would terminate a child support order. If a child enlists in the armed forces, we would terminate a support order. If a child is deported to another country, we would terminate the child support order. Not if the father or the mother is deported, if the child is deported. The child support order states that the child support shall not remain in effect after the child reaches 19 years of age, unless in a court child support order, the order provides that the duty of the support continues. So child support is ordered to be paid until the child graduates from high school or until they turn 19, whichever is the latest. So I will use myself as an example. I had a child who graduated high school at 16. His father asks questions. Well, does that mean that my child support stops because he is going to college? It did not stop. He had to pay until the child turned 18 years old, even though that was for 2 years of college, because 18 is the emancipation age. But if a child is in high school, accredited high school, then a person could end up paying until the child turns 19 or until graduation from high school. Okay. If the child is adopted, if the child is legally adopted, the child support will stop. If the person that's ordered to pay the child support passes away, the child support would stop. And the grandparents to whom support is being paid, or a grandparent who is paying support, reports that the grandparent support order should terminate. So we have in the past had cases where grandparents were ordered to pay support. And those cases are cases where the mother and the father may have been minor parents. And because of the custodial parent, mom and the child being on assistance through the state, then the non-custodial parent, parents, which would be that child's grandparents, could end up paying child support until dad was of legal age to pay child support. So those are the reasons why child support can terminate. Also, if we have a child support order and the parties, we set the child support order and the parties were not married, and then they get married, then that's another reason why we would terminate a child support order. And then resources, we have a web portal account. You can sign up if you have a child support case. You can sign up on the web portal, and you're able to talk with your case manager. You're able to send messages. You're able to check your payment status. You're able to see what's going on with your case if you register for the web portal. But the web portal service, it's easy, on demand, online access, child support case information. Like, you don't have to wait for somebody to call you back to give you that information. You can physically go on there and you can look at that information yourself. Quickly and conveniently view address, employment, and health insurance information, along with support orders and payment information. You can you can actually see 2 years worth of support payments on there. You can actually even print those off. You can send your messages, as I stated, to CSEA if you have a change of address or you need to update an employer. If you have new health insurance, you can do all of that through that web portal. Resource options for receiving support payments. And so this just tells how a person that is ordered to receive child support, how they can get those payments. Faster, simpler, safer ways to receive support payments are direct deposit, and that will go directly to your bank account. We also have our SMI1 Visa card, debit card. Your child support payment could go on that debit card. And so those are the ways they no longer send out checks. They used to mail paper checks out in the mail. So we no longer do those. We no longer send those checks out in the mail unless it's money that's being refunded. And then they may send out a paper check. If money is being refunded to the person that's ordered to pay support. So say a person's child support case was terminating, okay, and there was still money on hold, and that money is due back to that person that was paying the support, we would then mail a check back to that person to give them their child support that they've overpaid, or that child support that was not due. We mail that back to them. But these are the ways of our payments. Resource options for paying support. So we are we are still working remote, but we do have the abilities for people to go on still and make payments. And that's just the list, and it's very small. That's just a list to tell you how you can go on there to pay child support. It does say Venmo is only available on mobile devices. So, there's a number of ways: credit and debit cards, credit cards, cash payments can be submitted by purchasing a money order and sending a money order in. We do have a Dropbox as well. You can always drop off your payments in a secure Dropbox as well. So those are our ways that we can receive payments. Resources containing contacting, the Summit County CSEA. Currently, our office is closed to the public. And so we ask that if you need to contact child support, that you call our customer service line and you leave a message for a return call. That's where the web portal really comes in, because if you have a question, you can send it to that web portal, and then we have a whole department that just responds to web portal questions off your cases. You can do that. You can call and leave a message, and we have a customer service unit, and they listen to those messages and they return those calls. We also have that if you would like to see someone, you can set up a phone call to have a Zoom call, and you can meet with the caseworker or someone from legal or whatever the issue is that you may need to have addressed. We can set up a Zoom call for you to be able to have that issue addressed. And then this is just my contact information. My name is Shelly Woodruff. It has my email address and my contact information. I think that I saw that there was some questions.
There are a couple of questions in the chat. I can kind of backtrack through here. The first one, is it true that parents owe children's service child support even if the children are in custody of the county and under child protective services?
Yes. So if is it true that parents owe children's services child support? So that all depends. It's a case by case, and that's going to be something that would be issued by the court. There, in my time here, I have seen cases where juvenile court or domestic court has ordered for both parties to pay child support back, to the state or back to placement situation. So it just depends. That's going to be totally up to the court and what they have or what they decide. We don't address child support orders for cases like that.
I'm not sure if you can see, but the next question is, if a dad is on the birth certificate and a DNA test proves that the person is not the father, is that person allowed to be have their name removed? I'm guessing from child support or removed. Yeah. So
if a dad is on a birth certificate and a DNA test proves that he's not the dad, first of all, in the event that dad signed the affidavit and his name went on the birth certificate, he has to, or they have to go through the court process. And in order for a DNA testing to be ordered, it has to go through the courts. That's not something that you can just, hey, I'm coming in to get tested. I need to see if the child is mine. Once paternity is legally established, we will not address paternity again. The only way we would address it is if the court sends an order stating for us to address it. And in the event that an order is issued by the courts and it says that we are to establish paternity by DNA testing, if dad is proven not to be dad, then at that time it goes back to the courts for the courts to decide updating that birth certificate. They produce an order to have those changes made at that time.
And then the final question in the chat is, if a grandparents have to pay their child support, how is the support based? Is it based on the grandparents' income or the situation of the child finances?
So typically in grandparent cases, there's usually a minimum order that is set. And in past practices, that was always a $50 a month order, and it could be as much as $150. It depends on the entire situation. It's going to depend on the entire situation, because clearly we know if a grandparent is ordered to pay support, they have themselves established and they're paying child support for a grandchild. So there's usually a basic order whenever it's a minor child parent and a grandparent who's responsible.
Okay, thanks, Shelly. I think that's all the questions. If anybody else had any questions about child support, you can unmic and unmute yourself and ask a question.
I had a question I forgot to type in. With children that are disabled, is child support ever extended past high school graduation or the age of 18?
So that the Summit County Child Support Enforcement Agency, we can only address until the child is of legal age, until the child is emancipated. So until 18 or graduation from high school, or in some cases 19. Anything other than that has to be a court order that comes from the courts. I've seen cases that way, but they were all court issued.
Thank you.
You're welcome.
Okay, well, I guess that wraps it up for this evening at 7:45. Again, we seem to go over because we have a lot of information that we try to get through. I am going to do my best also to send out the PowerPoint from John. I may have to put it into a PDF format, so the videos may not play, but I'm sure that you'll be able to get the understanding of what they are. So thanks everyone for sticking around. Shelley, thank you for your presentation. John, if you're still on, thank you for yours. I believe we only have 2 classes left, and I know that we're still working on an in-person class for the last class, which I believe is 2 weeks from today. So Tanya will send out those emails and let everybody know the situation. But until then, I wish everybody a good evening, good week, and we will see you next Wednesday. Thanks again, everybody.